up to the counter. Right to the monitor. State your full name for the judge. Right here. Sir. Sir. Right here. Oh, right here, sir. So you can see by the camera.
Who am I talking to?
Judge Garvin, what's your name?
My name is Steve.
What's your full name, Steve?
My phone number is 928.
Your full name, sir.
Pardon me?
Your full name. That's what he's asking for.
My phone number?
No, your full name.
Oh, Stephen Greg Frederick.
Thank you. And sir, do you still reside on Phoenix Street?
What's that, sir?
Do you still receive mail on Phoenix Street?
Well, that's a kind of a sad story. My mother-in-law threw me out of the house. I'm homeless right now.
Okay. Do you receive mail there?
What's that?
Do you receive mail on Phoenix Street?
Yes, I do.
Okay. All right. Does your phone number end in 0678?
Yes, sir.
All right. The state is alleging 2 charges against you. Charge 1 is criminal trespassing in the 2nd degree, a misdemeanor allegation, and theft, which is also a misdemeanor allegation.
What? There is no theft.
Okay, but right now is not when you want to argue the case. I'm just informing you of the charges against you.
Okay, I don't understand that charge.
Okay, well, that will come later. You'll be able to understand it later. I'm just informing you now and setting release conditions, okay?
Yes, sir.
All right, so those are the 2 charges. On those charges, you have the right to remain silent, right to counsel, and right to trial. Your arraignment date is set for the 14th of January at 9 o'clock a.m., 2026, okay?
Okay.
That's where you give a plea of either guilty, not guilty, or no contest on that date.
Okay.
Depending on how you plead will be what happens next with the court proceeding, and all of those options, as well as the penalty range for both of those charges, will be explained to you prior to you giving your plea.
Okay. I think I understand.
Okay, well, you just have another court date on the 14th of January to plead either guilty, not guilty, or no contest.
Okay. Are they going to give me some papers?
Yes, I'll provide you a copy of everything that we're talking about now.
Okay.
Your release conditions are the following. When you're released out of custody, you must obey all orders of the court. Do not commit any crimes. Notify the court immediately once you obtain an address. Do not leave the state of Arizona without permission of the court.
Okay.
Do not contact the alleged victim by any means. And do not go near the location of the alleged offense. But if you have personal property there, you can take...
I have personal property there, sir.
All right, so you can call the police and have them go with you to collect your personal belongings.
Okay, I've already taken care of that.
Okay, so that's called a police standby. So you'll ask for a civil standby. Go to the property with them only. Don't go without the police, okay?
Okay.
Can you abide by those release conditions?
Yes, sir.
And you'll show up to court as ordered, and I'll give you a copy to remind you of the date?
Yes, sir.
All right, I'll release you on your own recognizance then, so you'll be released shortly. Do you have any questions?
Not this point.
Okay, that's all I got for you then.
So am I being released today?
Correct.
Okay. Thank you.
Until I get paperwork from the judge, and then I'll be able to get you out of here, okay?
Yes.
And we're gonna go right back to the beginning, all right? Can you right there for a second? that county, state your full name for the judge. Ready? All the way.
Hi there, could you state your name, please?
Roseanne Katzo?
Thank you. And ma'am, do you still live, is 2096 still a good email, or excuse me, mailing?
Yes.
And then your address is, pronounce the, is it Denahotso?
Yes, sir.
Okay. Where's that at?
On the reservation.
All right, which one? There's a lot of,
Kianta?
oh, Kianta, okay, thank you. Do you have an email address?
My last name, my first name, 05@gmail.com.
And your phone number ends in 4405?
Yes.
Okay. The state is alleging one charge against you, which is driving with a suspended, revoked, or canceled driver's license. That's a Class 1 misdemeanor. Being that you live so far away, what I'd like to do is proceed into an arraignment for you and take a plea from you instead of you having to come back on another day. Is that okay with you?
Yeah.
Okay, so to do that, I have to have you waive your personal appearance and authorize us to do this by video. Do I have your consent?
Yes.
All right. So the driving suspended, revoked, or canceled violation is a Class 1 misdemeanor that is punishable with a maximum fine of $2,500 with a maximum of 6 months of jail and a maximum of 3 years of probation. There is no jail time being asked of this case. So if you plead guilty or no contest, you're not facing any jail time. If you plead not guilty and are later found guilty after a trial, you're still not facing any jail time in a sentencing. Do you understand that?
Yes.
All right. You have the option to plead either guilty, not guilty, or no contest. The difference between a guilty and a no contest plea is the following. If you plead guilty, you're acknowledging the facts of the case and admitting that you committed the crime. If you plead no contest, you're not admitting or denying the facts, but you're accepting the conviction. Both guilty and no contest pleas show on a criminal history as a conviction. Do you understand that?
Yes.
Okay. If you plead not guilty, we'll schedule you at a court to come for a pre-trial conference. That's where you meet with the prosecutor. The prosecutor will discuss the case, may present the police report and any other evidence they plan on using at a potential trial at a later date. At the conclusion of that pre-trial conference, one of three things will occur. One, the case will in fact go to a trial. Two, the case could enter a plea agreement that all parties agree on, including you. Or three, the case could dismiss. Do you understand that?
Yes.
Okay. You also have the right to an attorney. The court cannot appoint you an attorney because there's no jail time being asked unless you provide other reasons that you need a court-appointed attorney. So your options are to provide a reason for a court-appointed attorney, waive the presence of an attorney in its entirety, or hire an attorney at your own expense. Do you understand that?
Yeah.
All right. Regarding the attorney decision, how do you wish to proceed? Waiving the presence of an attorney, hiring an attorney at your own expense, or giving the court a reason for a court-appointed attorney?
Where's that again?
So you have three options regarding the attorney. One is to waive the presence of an attorney, that you don't need one. Or two is to hire an attorney at your own expense. Or three, give the court a reason why you need a court-appointed attorney at little or no cost to you. You have to have qualifying reasons to have the court appoint an attorney. One of them would be if you were facing jail time, but since I informed you there's not jail time, that takes that ability away. So there are some other reasons. If you can think of a reason why you'd want a court-appointed attorney, let me know and I'll let you know if it qualifies or not. Otherwise, you either waive the presence or you hire an attorney.
I don't know. I don't understand it.
All right, so let me, I'll slow it down a little bit. So right now you want to let the court know if you want to hire an attorney at your own expense. If that's the case, I'll enter a not guilty plea for you and schedule you for that next pretrial conference, that meeting with the prosecutor. Or you're going to ask the court to give you a court-appointed attorney that costs you little or nothing, depending on the reasons why you want it. So I have to hear the reasons before I can grant it to see if that's even possible. Or you waive the presence in its entirety. You don't need an attorney at all. and you represent yourself, and then you give me a plea of either guilty, not guilty, or no contest. Does that make it easier for you? Let's say so let's say for example you're going to enter a guilty plea or a no contest plea. If you're doing that, which I'm not suggesting you do that, but if you're choosing to do that, then you wouldn't want an attorney unless you would plead not guilty, because the attorney couldn't do any work. So if you're intending on pleading not guilty to this charge, then you want to consider, do I want to hire an attorney to represent me? Do I want to see if the court will appoint me attorney? Or do I want to waive the presence of an attorney and I'll go to the pretrial conference myself? Or you plead guilty or no contest. Do you understand that, or is it still not clear? All right. So so you have the option to hire an attorney. Do you understand that? Okay. If you could answer yes or no.
No.
You don't understand that you couldn't hire an attorney?
No, I won't afford it.
You can't afford it?
I can't afford it.
Okay. So then you're left with two choices. Okay. Number one, not have an attorney at all and represent yourself through the court process, or you tell me a reason besides I can't afford it that you need a court-appointed attorney. Because to have the court appoint you an attorney, there needs to be two qualifications. Number one, I can't afford it. Number two, another reason, a mental disability, jail time, or something like that. Do you have any of those reasons?
No.
Okay, so then you're left with one of two choices. I don't want an attorney, I waive the presence of an attorney, or I'm going to try to hire one myself. So those are really the two choices you have.
Try to get an attorney, I guess.
So you want to try to hire an attorney?
Yeah.
Okay, so I'll enter a plea of not guilty for you, so that when you go try to hire an attorney, that they can give you an opportunity to represent you, okay? If you find that you can't afford it or can't do it, you are required to notify the court to let us know that you're not hiring one, so we can change the date that we're going to provide to you, okay?
Okay.
All right. May I ask a question from you? Could I get a non-custody court date for a justice case?
(127) 2 p.m.
2 p.m. you said?
Yep.
Thank you. All right, I'm scheduled you for a pre-trial conference. That's where you're going to meet with the prosecutor, or your attorney will, depending on who shows up, on the 27th of January at 2 o'clock p.m., okay?
Okay.
So try to hire your attorney between now and then, and they'll know what to do. They'll send us notice on this, okay?
Mm.
All right. I'm going to be sending you a form that waives your personal appearance that we talked about, so you're not in front of me. We're doing this by video. And then you'll see a part that I scratched out waiving the presence of an attorney. So that means that you're going to hire an attorney, okay?
Yeah.
All right. Now, I do see that there's some prior failure to appears in your background. If I release you on your own recognizance, what's going to guarantee me that you're going to come back to court? What's going to guarantee me that you're going to come to court?
I will show up.
You will?
Yeah.
Okay, because you have other times where you've told other judges that you will show up and you didn't.
Yeah, that's because there was nobody to bring me over there.
Okay, so you have between now and January 27th to make the arrangements to get back here.
Okay.
Okay, so you can't have that reasoning with this court because you have a long time to plan it out, okay?
Yeah.
All right, I'll release you on your own recognizance. Do you have any questions for me?
No, Your Honor.
Okay, that's all I have for you.
Okay, we're gonna head on that way. Bye-bye.
All right, I'll get it sent over to you shortly. Yep.
Yes, sir. Keep going.